v. Ohio 273 U.S. 510, 1927, is a foundational U.S. Supreme Court case addressing judicial impartiality under the Due Process Clause of the 14th Amendment. Holding, court held that it is a violation of due process for a defendant to be tried before a judge who has a direct, personal, substantial pecuniary interest in the outcome of the case. Facts. Tumey was convicted under the Ohio Prohibition Act. He was tried by the mayor of a village who, by law, received a portion of the fines collected upon conviction. The mayor also had administrative responsibilities to fund village operations from those fines. Issue. Did trying a defendant before a judge who had a financial interest in the conviction violate the 14th Amendment's Due Process Clause? Reasoning. The Supreme Court found that due process is denied when a judge has a direct, personal, substantial pecuniary interest in reaching a conviction. Even the appearance of bias is enough to violate due process. Justice must satisfy the appearance of justice. Rule. Judges must be impartial. A financial or other interest that may tempt a judge to rule in a biased manner violates the Due Process Clause of the 14th Amendment. Significance. This case is the origin of the Tumey Doctrine, which prohibits judges from adjudicating cases in which they have a financial stake or conflict of interest. It is used to challenge judicial bias and corruption, especially where courts are financially incentivized to convict or sanction. Let me know if you'd like to apply Tumey to a custody or family court situation, or if you're interested in related cases like Caperton v. A.T. Massey Colco, 556 U.S. 868 in 2009, which expanded on this doctrine. Tumey v. Ohio applies to family court when judges or the court system have financial, political, or institutional incentives that compromise judicial neutrality, especially in cases involving custody, child support, or dependency proceedings. Here's how it translates. Direct or indirect financial incentives in family court. Tumey's core principle is that a judge cannot have a direct, personal, substantial interest, especially financial, in the outcome of a case. In family court, this can look like Title 4D child support enforcement funding. Courts receive federal incentive payments tied to the amount of child support collected and enforced. A judge deciding custody in a way that increases a parent's support obligation could trigger funding advantages for the state. Court-appointed guardians ad litem, therapists, supervised visitation centres, and co-parenting evaluators often get referrals from the court. Judges may have relationships with these providers, and referrals can affect court budgets or local contracts, particularly if services are tied to grant funding. State dependency courts get federal funds under Title 4E when children are removed from parents. If reunification services fail and termination of parental rights is pursued, more federal funds may be available. Tumey Doctrine argument: if the judge's rulings help fund the court or related entities, even indirectly, that creates a systemic conflict of interest and a violation of due process under Tumey.
2. Structural bias.
Institutional loyalty over neutrality. If a family court judge makes custody decisions that systematically favour state interests, like maximising grant compliance or incentivising services, this is analogous to Tumey's mayor judge, who was part of the law enforcement system and had executive responsibilities intertwined with adjudication. For example, judges participating in state judicial councils or task forces that set performance metrics tied to outcomes, e.g. higher reunification or compliance numbers. Local courts needing to show successful custody mediation or enforcement compliance to continue receiving funding. Tumey Doctrine argument: a judge who is influenced by these systemic pressures cannot be neutral, just as the Tumey judge wasn't.
3.
Recusal and appearance of bias. Tumey also establishes that even the appearance of partiality is unconstitutional. In family court, if a judge fails to recuse from a case where they have prior involvement with litigants or with custody evaluators or other stakeholders, due process is violated. Judges ruling in ways that repeatedly favour court-connected service providers without evidentiary basis may suggest systemic bias. 4. Modern extensions, Caperton Veti Massey Coal Co. Caperton built on Tumey, holding that a serious risk of actual bias is enough to violate due process, even if no actual bias is proven. If a family court judge has relationships with local attorneys, GALs, therapists or evaluators who benefit from court referrals, is part of a court system that receives incentives when a parent is forced to pay child support, is more likely to issue rulings that maximise court